All right. Once we establish that this is a non-US person, the next question is this person getting a US source income? This is a critical question of huge importance and huge complexity. Why is it important? Because non-US persons generally, there are exceptions, but generally are taxed only on their US source income. This means that if the income that this person is getting is not US source income, then it's not taxed in the United States at all. On the other hand, if it's a US source income, then we have to go through a more complex situation. By the way, if it's not a US source income, as I mentioned, we still have to look into whether this is an effectively connected income. I'll discuss it a little bit later during the presentation. Now, I mentioned that this is a complex issue in terms of how you determine what is a US source income and what is not a US source income. So what I did is I'm going to simplify for you this analysis. It's basically a three-step process. First, you have to classify the income. That is it interest? Is it dividends, royalties, income from services, etc.? Then you have to find the particular tax provision that applies to this particular class of income. And the final step is to apply the particular facts of your client's case to that tax provision. Let's go over a few most common examples. If I can, oh, there we go. All right, interest income. Interest income is generally sourced to the residence of the obligor. Most often, obligor means the borrower, of course. Not always, but most often. This rule applies to individuals, corporations, and partnerships. Now, the interesting thing is that it may lead to some very unusual situations. For example, if a US person resides in France, and this US person is an obligor, and the obligee, a French person, resides in the United States, and the US person pays interest on the income, on his obligation, on the loan, then this interest would be classified as foreign source income, more precisely French source income, even though it's a US person who is paying it. Again, a residence of the obligor, not the nationality. Dividends. Aside from some limited exceptions, depends on whether the corporation that pays a dividend is a foreign corporation or a domestic corporation. Dividends paid by US corporations is always US source income. Dividends paid by a foreign corporation is almost always a foreign source income, but there is this important 25% exception. Basically, if 25% or more of the corporation's gross income for the past 3 years was ECI income that is effectively connected to the trade of business in the United States, then you have to apportion this dividend between the percentage of ECI income versus foreign source income. So think about it. What it means is that a foreign dividend from a foreign company incorporated in a foreign country, and this dividend is paid out to a foreign person who lives in a foreign country, actually may result in US source income. This is a paradox. This tells you just how complex US international tax law is. And just to mention it, prior to 2005, technically speaking, unless there was an exception, and there were a number of exceptions, including treaty exceptions, but technically speaking, if no exception applies, this person would have been expected to file a US tax return and pay US tax on that US portion of his foreign dividend. Of course, that would almost never happen, but there was some litigation in the early years. All right, rents and royalties. Source to the place where the property is used. This rule is going to be very important with respect to tax planning that involves intellectual property. Sales of personal property, extremely complex because you really have to dig into the facts of the case. So where in general, sales of personal property are sourced to the residence of the seller. There are special rules for depreciable personal property. And there are special rules concerning a situation where there's a permanent establishment outside of the United States or inside of the United States, actually, as well. But the biggest issue, and this is going to be very relevant for the purposes of inbound transactions, is sale of inventory. This situation is very common. For example, a few years ago, I had a case where a foreign parent was producing some goods inventory and basically sending it to a distribution center here in the United States. And the general rule here is that inventory sales are sourced to the place of sale. Very important, source to the place of sale. What is a place of sale? Generally speaking, it's a place where the title is passed, but it gets a lot more complex. There are some exceptions that I've given you. So for tax planning purposes, this is a huge issue when it comes to inbound transactions. All right. Sale of US real property. Generally, US source income, even if this US real property is held through another entity. And then income from services. That is sourced to the place where the services are performed. So for example, if you go to France, perform some work there, and get paid for that work, even though you're a US citizen, even if you don't reside in France, the payment that you receive for the services performed in France is going to be considered French source income. It gets more complex if you perform services in more than one country, but then you have to apportion the payment between these countries. And the usual method is time basis allocation.